Okay, good afternoon, good evening, good morning, depending on the time zone. Thank you very much for joining us for this next session, which is in the format of a panel discussion. I will be joined by by Dr. Halahouri Bisharat, Professor Eyal Benvenisti, and Professor Helen Duffy. Thank you very much for joining us. We do have a fourth speaker, which is Professor Ben Saul. Ben is currently in Australia, and due to humanitarian reasons that relate to time zone differences, I did record yesterday a conversation with Ben around the topic of the conference, so of the session. So what we will do, I will briefly introduce the topic and the speakers. Then we'll watch the conversation with Ben, and then we will move to the panelists and ask them to address both the general and specific dimensions of the panel. So the panel deals with domestic law, domestic courts, and the regulation of war. We were interested since this conference deals more broadly with the constitutional law and IHL, we thought it would be probably impossible for us to ignore recent events, the recent outbreak in hostilities between Israel and Hamas in Gaza, and the increased relevance of law to this conflict, both before we are seeing, of course, the active involvement of international courts. But I think we've also seen in the recent conflict a growing interest and growing involvement by domestic courts, probably most spectacularly here, third-party state courts, domestic courts, dealing with over and beyond the regular issues that we have, so to speak, have become used to see in the aftermath of war, such as attempts to put war criminals on trial or attempts to bring tort cases. I think we're increasingly also seeing other new avenues, such as cases challenging decisions to supply weapons or parts, etc. And this, I think, raises interesting and important questions for us about the involvement of domestic courts. As well as with regard to perhaps the challenges and maybe the limits that resorting to such courts may involve. We have really an excellent panel of speakers. I don't want to spend much time in long introductions, so I would go very briefly and introduce them. Professor Ben Saul, who will be, as I said, the exceptional speaker in the sense that he has been pre-recorded, is the Challis Chair of International Law at the University of Sydney, and also the incoming UN Special Rapporteur on Human Rights and Counterterrorism. Professor Eyal Benvenisti, who certainly does not need introduction in this forum. He was also a former director of the Minerva Center many years ago, but he is, of course, now the Yule Professor of International Law at Cambridge, where he also directed for many years the Lauterbach Center for International Law, also a global professor of law at New York University, and a member of the faculty of Tel Aviv University, of course, a very big name in international law. Professor Helen Duffy from Leiden University, a well-known expert in human rights and humanitarian law, and has a lot of practical experience, her expertise is really strategic litigation, which deals with the interplay often between international law and domestic institutions, which is why we have invited her for this panel, and we're very glad that she accepted. So she is involved in practical programs, but also has extensive NGO experience in the world of NGOs, but also in the world of representing government services in investigations. And last but certainly not least, Dr. Hala Khoury Bisharat, who's been a long friend of this series of conferences, a PhD from Oxford University and a lecturer in the Ono Academic College, also the director of its Haifa campus and an adjunct in Tel Aviv University. And Hala has been researching for many years international criminal law, even before it became very popular and well known around this country, but also specifically transitional justice and human rights. So without further ado, I will ask the powers at the Minerva Center to maybe play the tape. Hopefully all the technology issues will work fine. There we go. So good day. We are joined online due to time difference issues by Professor Ben Saul, who's the Chalice Chair of International Law at the University of Sydney, and also has been serving for about 6 months as the UN Special Rapporteur on Human Rights and Counterterrorism. Thank you very much for joining us, Ben, for this.
Good to be with you, Yuval. Good to be with you.
Right. So as you know, this panel deals with the interplay between domestic courts and IHL from comparative perspectives, and also with relating to in relation to the specific Gaza conflict. Maybe we can start by hearing from you a little bit about what do you perceive as the role that domestic courts and domestic laws actually play with regard to armed conflicts, and what trends, important positive or negative trends, do you see in this regard in recent years?
Thanks, Yuval. And I'm talking as in my academic capacity rather than as UN Special Rapporteur. Look, I would say over the last 2 decades or so, since the Rome Statute in 1998, and then since the terrorist attacks of 9/11, there really has been a proliferation of international humanitarian law in domestic law and in domestic courts. And as a result of the war on terror, lots of campaigns where coalitions of states have been involved in fighting wars on terror, and that, of course, has driven a lot of interest in how humanitarian law is applied, interpreted, how it's used for accountability purposes in universal jurisdiction, war crimes cases as well, in places like Afghanistan and Iraq. I mean, from my perspective on counterterrorism, of course, there's a whole debate over the last 2 decades as well about whether and to what extent counterterrorism law applies in armed conflict. And some international treaties and regional laws and national laws have exemption clauses for armed forces in armed conflict, as well as state armed forces more generally. So it has been a growth area, to be sure. I just mentioned one example from my part of the world, Australia, which has been very much involved in the war on terror in a bunch of conflicts in recent decades, and the quite shocking occurrence in Afghanistan, where an official inquiry by the Australian Inspector General of Defence uncovered at least 39 suspected war crimes of murder by about 24 Australian Special Forces soldiers in Afghanistan. And this led to a lot of soul searching in Australia. Fortunately, the military leadership and our government were on the same page. They were shocked by this, and they wanted to make sure that they did the right thing, and also avoided International Criminal Court scrutiny, because we're part of that court, by thoroughly cleaning the military's house. So there was an exhaustive administrative inquiry. It gave immunities for soldiers who testified, so that they couldn't be prosecuted on the basis of the testimony they had given. But that then resulted in the establishment of an office of a special investigator just 2 years ago. It's been staffed with 150 staff, over $100 million in budget to really reopen criminal investigations into these cases and to lead to the laying of charges. And so that process is underway. One soldier has been charged already. While this was happening, of course, our most decorated soldier, a Victoria Cross winner, Ben Robert Smith. Victoria Cross is the Australian and British Empire's most highest military honour for bravery. He decided to sue for defamation in an Australian civil court to clear his name because media had reported that he was involved in some of these murders in Afghanistan. This trial went for a couple of years. It was just decided at the end of last year after $25 million in legal costs, lawyers on both sides. And it was a spectacular own goal because the court found on the civil standard of proof that he was responsible for 4 murders of unarmed prisoners. So all of these cases, 39 murders by Australian forces, were not in the heat of battle. There was no question of conduct of hostilities issues. They were all unarmed prisoners in the custody of Australian forces who were essentially murdered in cold blood. So there's still a long way to go. Australia has accepted a recommendation to compensate the victims' families. But in some of these cases, it's almost 10 years and Australia has still not compensated because of, it says, the difficulty of dealing with the Taliban authorities and anti-terrorism sanctions and issues like that. There are still some outstanding issues. Some people have criticised the lack of command responsibility for more senior officials who might have known about this and didn't do their job to take measures to prevent and suppress those breaches. And there's also, as is common, I think, in lots of countries, some blowback at the public and political level. Some opposition politicians asking, why are we putting on trial our war heroes for fighting terrorists? Sounds familiar in Israel, I suppose. Also, even Facebook groups dedicated to these war crime suspects, calling them heroes and trying to get them exonerated. So, this is a familiar story, I think, but full credit to Australia for taking this seriously, much more seriously, I'd say, than the United Kingdom or the United States. Both countries also accused of serious crimes in Afghanistan and elsewhere. To be fair, in the war on terror, Iraq and rendition and Guantanamo. I mean, there's a long list as we know. But I think the fact that they've given so much money, so many resources, and are committed to prosecuting under our universal jurisdiction war crimes legislation is a rare win for accountability and international justice.
Right. Now, one of the interesting things that we have been seeing in connection with the Gaza war has been an increased involvement of third-party courts in reviewing the war from a variety of perspectives. There have been cases concerning military exports that have been litigated in a number of venues, and I think you have in one of your statements you have commented, I don't know on legal proceedings, but generally on the obligations that states might have in that regard. And of course, there have also been some calls, which I'm not sure whether they have been picked up so far to apply universal jurisdiction so as to put on trial be they Hamas or Israeli leaders for crimes. So how do you see these third-party court cases? What sort of hope do you think we should assign to them, and whether you have any comments that you are willing to offer at this stage with regard to how domestic courts have dealt with the Gaza situation?
So as you say, Yuval, there are lots of different contexts in which foreign domestic courts have been looking at these issues. And another one I'd mention is dual national Israelis who might return to their other country and then find themselves under investigation for what they may or may not have done in Gaza. One area I have followed pretty closely is decisions about arms exports to Israel, because that's an issue as a UN Special Rapporteur I've looked at, and in the Netherlands there was a court of appeal in The Hague which essentially ordered the Dutch government not to export F-35 fighter jet parts to Israel on the basis that it found that there was a clear risk of that they would be used to violate international humanitarian law in the war in Gaza. Now, cases like these have come up in the US and some various other places. I think they raise raise some pretty interesting issues. I mean, here in Australia, the problem is that all of our arms exports are just secret. So the fact of an arms export permit being granted is made public, but what's exported in that shipment is completely secret. So it's very difficult to know, whether, if you don't know what the weapons are, whether they're being used to commit violations in another country. The Dutch case was interesting because it raised questions of, what is the applicable legal standard or test for assessing arms exports in conflict situations. And if you look at different courts, it really depends in a way on the different suite of obligations that state has. So it could be the arms trade treaty standards of due diligence and prohibition. It could be the duty to ensure respect for international humanitarian law, including in foreign conflicts under Common Article 1 of the four conventions. It could be the Genocide Convention, because that's, of course, in play in a number of proceedings as well. Or it could be under domestic law, sui generis standards. So some states, for example, have more protective standards for arms exports, so that if there's a risk of end user violations, so you export to state A, it then exports or transfers onward to state B, that second leg is covered by national law assessments of whether there'd be violations at the end of that chain. So this has also played to the question of what is the level of risk at which you have to stop exporting as well. It involves issues of proof. I mean, in the Dutch case, the court made clear that this isn't a criminal standard of proof. You don't have to show specific violations in individual attacks. This is also a point made by the Biden administration recently, when it warned that there is a pattern of violations by Israel, but it couldn't identify specific violations. The Dutch court simply said, look, based on all of the evidence, and it took account of UN materials, incriminating social media posts by Israeli soldiers themselves, statements by the Israeli leadership. After reviewing all of that evidence, it said, look, that's enough to establish that there is a clear risk based on deliberate, disproportionate, indiscriminate attacks of various kinds, as well as the humanitarian situation which it found Israel was responsible for. There's also a lack of trust in the Israeli military justice system to get to the bottom of those violations, and so that was, part of the problem of it not being safe to continue to export. A final point I think I'd make about this is just that because whether it's for arms exports reasons or otherwise in foreign domestic courts, I think part of the problem is that every country and court system may well come at international humanitarian law issues differently, depending upon their national law framework, interpretations of humanitarian law by their own state. And I think one of the issues we've seen play out in the last 6 months in Gaza is just fundamental differences of approach, interpretation, opinion between different states on how you apply humanitarian law. So, if the US earlier in the conflict says Israel has not violated international humanitarian law, maybe that's because it takes a different approach to proportionality assessments than, for example, the Dutch courts might take. And we've seen some pretty wild proportionality assessments in the media, at least. I don't know if these are true, but 20 civilians tolerated as lawful casualties for striking one low-level Hamas fighter, or a more senior Hamas leader could justify 100 civilian casualties. Now, those are ratios you'd never accept in the Australian military, I can tell you. But because IHL is slippery and is ambiguous on a whole range of issues, is the military objective the whole apartment block or just the apartment? Who qualifies for direct participation in hostilities or membership of an armed group? What precautions are feasible or not in a given attack? What choice of weapons should have been made to ensure an attack was not indiscriminate in urban warfare? What's the standard of intention for the war crime of starvation? So there's so much room for argument that we know that, even amongst close allies, Australia and the US take quite different approaches to interpretation of issues like proportionality. So it's no surprise then that there are quite different assessments in different countries of what's going on in Gaza. So I think, to conclude, I think for me it does emphasize the old problem that humanitarian law, of course, has to have general standards to fit the variety of situations in which it factually is applied. But at the same time, I don't think we've got enough consensus on at least the core of issues like proportionality and what is a legitimate military objective. And it would be useful if there was some kind of new key or consensus forged, maybe through a soft law process, to get at least some tighter boundaries on some of those very fundamental rules.
If I may, just a quick follow-up, and that is also relevant to your mandate and to your expertise in counterterrorism. One of the traditional problems that we've had with these sort of court cases was that courts were quite reluctant to actually legally evaluate policies that were seen as quite central to national security and also to foreign relations. However, the Dutch decision you have described, and some other proceedings of that nature appear to deviate from this more traditional, you could say, conservative stance. Is this something that you, and the same might go for domestic review of accountability related issues. Do you see a trend in this regard of courts, domestic courts being more assertive in speaking law to national security and foreign relations authorities?
Yeah, I think it's fair to say that that's true, and it goes hand in hand with the proliferation of international legal standards generally, which are more certain and precise than perhaps they used to be in the old days. I mean, judicial deference to the executive or to the sovereign prerogative back in the monarchical times, it came about at a time when international law was pretty limited and thin on the ground and sometimes quite vague. We don't live in that world anymore. I mean, there are precise international humanitarian law and international human rights law standards and international criminal law standards. They are justiciable. There's nothing inherently political or non-justiciable about them. At the same time, of course, courts have to give due deference to executive judgments in areas where the separation of powers warrants that, and where courts, may not have that expertise. But I would caution that, sometimes judicial deference is comes about because courts are not don't make a sufficient effort to gain the expertise that they could gain to make the decision according to legal standards. In very complicated multinational tax cases or mergers and acquisitions cases, you never hear judges saying, "Oh, we don't have sufficient expertise in, the economics of tax or mergers and acquisitions to make this decision, so we'll just give a free pass to corporations." So I think for me, there's a bit of a judicial responsibility here, just because you're not familiar with national security cases conventionally, because maybe there haven't been many in many national judicial systems, or you're not familiar with the application of international humanitarian law to foreign conflicts, because that is really rare. It is incumbent on judges to take expert evidence, like they do in every other kind of case, to get on top of the legal standards that apply, so that they can do their job as judges. These are legal standards; they're not political, non-justiciable ones, and it is the role of courts to uphold them according to law.
Okay, Professor Ben-Saul, thank you very much for these interventions. And I hope we could find a time in which we could have you live next time, either virtually or physically. So best from all of us in Jerusalem.
Absolutely. Thanks for having me, Yuval, and good to chat. Take care.
All right, and we are live again. This is like a small TV show. And now so we've heard this initial presentation or conversation with Ben, and now I want to turn to the rest of the panelists, and we've agreed that we will have two rounds of discussion. One talking more generally about trends with regard to domestic courts and the evaluation of legal aspects of wars, and then we'll talk perhaps specifically about how we see domestic courts functioning in connection with the Gaza war. So perhaps Eyal, you could lead the way and take us forward.
Thank you, Yuval. I listened very carefully to this very interesting conversation with Ben Saul, there's a lot of agreement between us. I would say that with respect to the first question, the role of domestic court and in regulating or addressing war situations, and the last couple of years or last 2 decades or so, I think what we see is a growing emphasis on the need to ensure that the process of decision making is taken care of seriously. That it all, I think, in my view, all derives from the concept of command responsibility. So under the laws of war, international humanitarian law, the need or the obligation on the commander to make sure that there are no crimes committed and repress when they find that there are crimes that have been committed. And so this is then developed to a number of procedural obligations, obligation to have this monitoring capacity. Nobody is immune from investigation. The investigating body must be independent and impartial. The process has to be public, and the monitoring body itself must be accountable. The monitoring agency must have access to information and must conduct its monitoring function in a timely manner. And then part of it, I think, is the need to have this process reviewed also independently and impartially. And I think with these developments, these developments have been, I think, acknowledged in Israel by the Technical Committee, and I remember you, Yuval, and I and others testifying before the committee. And they propose a number of strict obligation on the Israeli army, and that's part of, and they reflect, I think, customary international law. Now, I want to emphasize that, and I think it's part of the theme of the conference, which is also constitutional law, that these obligations are also incumbent on the military establishment under domestic law, under domestic constitutional law, and the idea that you don't have authority without accountability. And also the fact that these matters, these violations of IHL, potential violation of IHL, are criminal acts. So they should be subjected to domestic criminal law. I would say one thing about foreign courts. I think the proliferation of claims or petitions in foreign courts is reflecting the growing sense that nobody can remain neutral if there are grave violations of the laws of war, the war crimes against humanity. These are erga omnes obligations, so are applicable to all, and everyone can see themselves as affected by these crimes. And so the idea of neutrality becomes a travesty. And I think we see it clearly after the invasion of Ukraine, when the German government said we no longer remain neutral. And that, I think, was a pivotal moment, because until that moment, people thought that, well, you can be neutral, there's no obligation to get involved. But I think when these horrific crimes committed and a violation of the basic principles of international law, that would affect everybody, and nobody can remain neutral. This raises the question that I think Ben raised. I think it's a hugely important question, and I don't think we have good answers to, which is how to address the different perception of the laws of war. So, in the context of starvation, if you read the UK manual from 2004, starvation is subject to proportionality. If you read the US Department of Defense document from 2016, you can't really impose a siege if civilians are adversely affected. So you see the differences, and you see the law evolves, and the law evolves through these judgments. And what happens if different armies have different manuals? I don't think we have a sufficiently convincing answer to this question at the moment. Thank you.
Right, thank you. So we talk about military interoperability, but we might start talking about judicial interoperability as well. Helen, can we turn to you? And we would very much like to hear your thoughts on this question.
Thank you so much. I hope you can hear me well. It's a real pleasure to join you here. Yeah, I thought I would just say a couple of things about, you've asked about developments and trends, but also about some of the challenges. And I've tried to make a couple of broad brush comments and then maybe give some examples from my own practice. I mean, I think one thing that I've been really struck by recently, I've been doing an inquiry into strategic litigation in armed conflict. And so looking around the globe at different types of litigation that's been brought. And I think what we see is just really a remarkable level of engagement of different courts around the world with really diverse issues arising in armed conflict, involving a whole array of different actors. So many different types of litigation being used: criminal, civil, other, against individuals, against non-state actors, particularly corporations, against states, on the national level, and of course complemented internationally. So I think I was really struck by just the extent to which litigation is being used, despite all the challenges, which I'll come on to in a minute, but the extent to which litigation, I think, is being used in really diverse ways, and with quite remarkable results, I think. I mean, not talking about Gaza or Israel at the moment, as we'll come back to that, but looking at other situations, there are many examples of territorial processes. If we think about criminal accountability, first of all, of examples often many, many years after conflicts are over. So we have to acknowledge that as an immediate limitation. Sometimes decades later, where we see accountability still underway. And we could think of processes where I used to work in Guatemala, in Argentina, may not have been an armed conflict as such, but comparable in some ways, in the DRC. But there are also, I think, many examples during conflict. And of course, we've got an expert from Colombia, where there have been some remarkable engagements, domestic courts. And Ukraine, you also had Ukrainian experts here, where hundreds of thousands of cases are open during the conflict itself. So criminal accountability in situ, and then of course universal jurisdiction. Also, I think it's worth noting that that is an area of expansion, because sometimes there is a perception of universal jurisdiction on the retreat, and that's really not true when you look at some of the particularly cases related to armed conflict. For example, Syria-related universal jurisdiction cases have been quite widespread now, particularly in European courts, particularly because of the role of the Syrian diaspora in Europe. So we're seeing a lot of results there. Civil cases, for example, it was mentioned, Ben mentioned the role of the UK has been somewhat limited in many ways in its accountability around the war on terror. I would certainly agree with that. But it did spring to my mind as he was saying that there have been hundreds and hundreds of cases settled by the UK in relation to Iraq, for example, and in relation to civil claims that were brought concerning violations in that context. And then I wanted to mention that sometimes there are other forms of litigation that maybe fall off of our radar and we don't think of, but that are also quite interesting. One example there, controversial but interesting, would be the role of immigration processes, for example. And you may be familiar with a recent case in the US courts called the Mohammed Jabata case, where a Liberian individual accused of war crimes was sentenced to a very long prison sentence, not based on the war crimes allegations as such, but based on the fact that he lied on his immigration procedure and therefore was held responsible under that body of law. So using other bodies of law. Corporate responsibility, massive area of development, many cases in France, holding both corporations criminally responsible as well as civil responsibility, cases against social media companies, against surveillance companies, as well as the arms dealers that we've talked about. So I think we're seeing, litigation really expanding to look at the multifaceted role of lots of different actors, states, individuals, and non-state actors. And maybe just a couple of words about challenges, and maybe we can come back to this in the discussion, because of course, as a human rights lawyer, I could talk about challenges for decades, and I'll have to exercise restraint. But I think there are a couple. I think it's important to name that I think the challenge of political will infiltrates an awful lot of this area, not only in terms of holding individuals to account, but many other areas of legal practice around armed conflict litigation. But also, I think a lot of legal obstacles, and some of them have been referred to. Of course, domestic laws vary, but we still do have, I think, around the world, a lot of obstacles to deal with around issues like amnesties, immunities, statutes of limitation, questions of non-justiciability that, of course, others here will be very familiar with, approaches to state secrecy and transparency that give rise to many challenges, certainly in my line of work in trying to bring forward effective human rights litigation. Sometimes even questions, maybe less obvious challenges that are worth flagging and that come up in practice. I do a lot of work around rendition litigation and torture victims of the war on terror. And one recent issue that came up in UK courts, for example, where we're suing the UK government for its role in complicity in rendition by providing questions to be put to people while they were being tortured and in the knowledge that they were being tortured. And one of the issues that came up there is just the question of which law applies. Applicable law, do you need to argue in a civil case based on the law where the violation may have arisen? That, for example, in a case involving CIA rendition around the world would have meant arguing it on the basis of 7 laws around the world. So that's maybe just a quirkier example, a less obvious example of the many disputes that arise around applicable law. The issue of the role of the courts in policy, judicial policy, foreign policy, has already been raised, and maybe we can come back to that in discussion. I think it's crucially important because potentially, if there's an expansive approach to this is taken, it really would preclude a great deal of important litigation. On the other hand, of course, it's not about the court taking over the important role that lies with other arms of the state. So clearly there is a balance. What I see in my work is there are vastly different approaches to that around the globe. I don't think that we do see one emerging trend. I think we see very different approaches to that. maybe just the last thing I'll say, I'm probably going way over my time. I promise to be briefer next time. As I say, never ask a human rights lawyer about challenges, but I think it has to be said. I think one of the things that we do also need to identify that ties in with one of the previous speakers are just the extent to which judiciaries around the world and justice actors more broadly are under threat and under attack. And that's a huge issue, really, in terms of enabling rule of law responses to what's happening in an armed conflict. That's not unique to armed conflict, but it's greatly intensified. So real problems with judicial independence, which I work on a lot in my cases, but also, of course, attacks on civil society organizations, clamp down on dissent, on protest, on people bringing litigation, being perceived to be doing something that is itself anti-state, and therefore being themselves subject to reprisals, criminalization, etc. So many different challenges, but I think what we are seeing is increasing engagement of courts in lots of different ways, in a complex, but in some ways promising as well as challenging landscape.
Okay, thank you very much, Helen. And yes, you have gone over the time a little bit, but I think we're still fine. I also would note before turning to Hala that we already have some questions at the Q&A box. So those of you in the audience who want to write questions are invited to do that, and I will then pick up a few questions and turn them to the speakers before the end of the session. So Hala, to you, I mean, what is your take to the maybe trends in the engagement of domestic courts or domestic laws with war situations? No, we can't hear you, Hala. You have to unmute.
We are very much witnessing in the recent years the national courts prosecuting abroad, specifically in European Union countries, prosecuting under the principle of universal jurisdiction when it comes to perpetrating jus cogens crimes against humanity, war crimes, genocides, and torture. The thing is, when Professor Eyal Ben-Benisti said that nobody can stay neutral these days, I very much agree. It's not only nobody can be neutral. Because of the legal situation in Israel, there is no access to courts, and the culture of impunity is prevailing. So when we talk about universal jurisdiction, it functions upon also the principle of subsidiary, meaning foreign courts will get into the picture and investigate and prosecute if the relevant state is unable or unwilling, or the legal system is not doing what it should do. In the past years, not only all during all the arms conflicts between Israel and the Palestinians and between Israel and Gaza, we have seen the suspension of the rule of law. And I want to give some examples to illustrate what I'm saying. For decades, Israel has used its domestic law enforcement system as a whitewash mechanism to deflect international criticism. The system does not investigate the orders themselves of the army, nor the responsibility of those who issue them or who determines the policy. I agree with Professor Eyal Ben-Benisti about the Turkey. We know a good, really serious work has been done on this part, but we don't see any real implementation and no results, really. Palestinians have no access to justice. If we take, for instance, the Becker case, the Becker boys killings, the 4 boys playing football on the beach of Gaza in 2014, and the military closed the investigation, and the refusal of all levels of the Israeli legal system to hold the military accountable reflects a policy of total immunity. The Israeli Supreme Court rejects the petition also against closure of investigation into the Becker boys' killings. Another prominent case is the case of the wounded and injured and killed during the March of Return in 2018, when there were violent incidents during the Great March of Return protest near the fence separating Gaza and Israel. Hundreds of Gazans were killed and thousands were injured as the Israeli military used a live ammunition, live fire sniper against Gaza protesters. The Supreme Court of Israel fully adopted the Israeli military position, refused to watch videos documenting shooting of Gaza demonstrators. There was a UN commission, independent commission of inquiry that was established concerning these incidents, and the UN commission of inquiry stated that Israeli use of live ammunition is illegal. Rules of engagement approved by Israeli Supreme Court violate international norms. Israel government hasn't meaningfully investigated and prosecuted anyone responsible for crimes against Palestinians. You know, the other day when we heard the advocate Noam Gilad at the ICJ, when he was representing Israel's case before the ICJ and South Africa's case, and Advocate Noam Gilad said, and I'm quoting, that when the roars of cannons, when the cannons of war roar in Gaza during the war, the law is not silent, but unfortunately the law in Israel is not only, it's deaf towards any Palestinian claims, any Palestinian injuries. And another dimension of this culture of impunity, the dimension of the civil, civil litigation, is the Israeli court closed its doors to any civil litigation coming from Gaza's civilian Palestinians from Gaza, even if they were not injured during any combats activities, as known as the Nabahin case. In the Nabahin case, the Supreme Court actually said that just a minute, the law that gives the law of compensate, the law of 2012, under which residents of the Gaza Strip are effectively banned from claiming civil remedies against Israeli actions, including unlawful actions with no connection to active situations of armed conflict. The Supreme Court upheld the constitutionality of this law, banning any Gaza citizen from approaching Israeli courts, because Israel declared Gaza as a hostile enemy territory. So anybody coming from Gaza, anybody injured in Gaza, no matter what his injury, even if he was just protesting, even if he was just passing through Nabahin, the Nabahin boy, he was 15 years old, going back to his house 5 meters from the fence separating Gaza and Israel. This is his homeland, the land of his house. I mean, he was going home and he was shot by a soldier. And of course, nobody held accountable for his shooting, and his family couldn't even seek any compensation, no accountability. So I think it is crucially important that all international accountability measures are open to Palestinians being, victims of violations of international humanitarian law during armed conflicts. Thank you.
Thank you, Ala. So we'll do a second, maybe a bit shorter round in which I would invite members to, maybe if you want to either react to what we have heard, or to deal specifically with in the framework that we have discussed with regard to the Gaza war, and how do we critically maybe evaluate the performance of courts. I mean, we heard already from Hala some skepticism about, well, strong skepticism about the utility of the legal system in this regard. But maybe we can also have something to say about the potential of other courts or the way in which other courts have inserted themselves. So maybe, Eyal, we can turn back to you again to address some of these issues.
Yeah, thank you. So, following up on Hala, I think that the burden of proof is indeed on the Israeli courts and investigating teams. Before the ICJ on 12th of January, Israel has asserted, among others, and I quote, that as the Attorney General reaffirmed publicly recently, any statement calling for international harm to civilians contradicts the policy of the State of Israel and may amount to a criminal offense, including the offense of incitement. Several such cases are currently being examined by Israeli law enforcement authorities. This was on the 12th of January this year. The court, in the orders that the court issued on 26th of January, referred, among others, to the obligation of Israel to take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in Gaza Strip, and the state shall also take effective measures to prevent the destruction and ensure that the preservation of evidence related to allegation of such acts. So I think we are, and I must, as people here know, I was counsel to Israel on this case, but as a citizen and as a professor, I'm still eagerly waiting to hear the results of the investigation of the Attorney General. Not only in that specific, in general, with respect to the specific incitements, but also with respect to subsequent events, including the famous incident of the World Central Kitchen, where the members of the volunteer unit were hit one after the other, and here the facts must be ascertained, because otherwise it seems like a premeditated attack. And the third point I want to make with respect to the war in Gaza or any other war, that, and this goes back to the need to be accountable. You need to provide evidence. It's not enough to say that we are not. It's that we are not intending to harm. You have to show the evidence, and for that you need to make sure that the units on the ground are providing the necessary information. So the idea of having reporters embedded with the troops is a point that needs to be taken care of. And I think in previous wars or conflicts, there were such efforts to accumulate and to provide, and then after disseminate information. I'm not sure that's also the case in this current war. Thank you.
Thank you, Eyal. Helen, do you wish to add a bit more, and maybe also, since I don't know how much you have been involved in the Dutch hearings, but this has been already noted both in the Q&A and also in Ben Sol's remarks, and maybe you could also identify some more challenges if you can find.
You'll regret that, asking me for more challenges. No, but maybe just a couple of words, because I didn't speak specifically on Gaza-related litigation. I think obviously that I agree completely with what Professor Benveniste has just said about the importance of criminal accountability in this context. That clearly has to be a priority, and others know better than I do the situation in the Israeli context, where obviously would be the most natural forum for that kind of criminal accountability. I think when it comes to universal jurisdiction, I think while there has been very little UJ activity in relation to Israel, there has, of course, in the past been various efforts. We can talk about universal jurisdiction as a method of accountability for Hamas individuals, as well as individuals accused of various crimes in Gaza. I think we're bound to see a lot more of that, and it's not surprising, I think, that we haven't seen so much of that yet, because that, of course, does depend on various things. It depends on a great deal of criminally appropriate evidence and process and opportunities and engagement. So I don't think it's so significant, but of course we'll see more of that, just as we will, I think, see what happens with the ICC in light of recent engagements. I think what is really interesting about the role of foreign courts is indeed the way in which, both in relation to state policy in the UK and the US courts, there have been cases that have been brought in relation to the support provided by the US and the UK for Israel in relation to military operations in Gaza. And as I'm sure people know, the case that was brought in the US courts was ultimately rejected. But even then, I think it's interesting the way that cases are rejected when they are, not just the fact that they are. And there was some quite, I think, powerful language from the judge saying, we won't do this because of the deference around foreign policy that we've referred to. But certainly been quite, I think, critical of the Biden administration, also referring to the ICJ proceedings, for example. In the UK, that case is still pending. And very interesting, certainly, the blocking of the transfer of defence equipment in the case that Ben Saul has referred to. I wanted to mention one other case that I am involved in, partly as a reminder, I think, that some of the issues that we're seeing now, not only the facts, but also litigation and judicial responses are not new. I represent someone in a case that went forward through the Dutch courts and has now gone on to the European Court of Human Rights. And this is an individual, Ismail Ziada, who lost his family when they were killed during Operation Protective Edge in 2014. He then brought a civil claim in the Dutch courts and against Benny Gantz and Amir Eshel, who were, of course, military commanders at the relevant time. And that case was thrown out by the Dutch courts on grounds of immunity. And they said that the immunity of the state extends to the individuals that were acting on behalf of the state in civil contexts. And they made a distinction then between criminal law, where we see more and more exceptions to immunity, to civil context, where they took a very broad brush approach to immunities. So this is an issue that we'll see going forward as we see more civil cases coming forward. We've challenged that approach to immunity and said it's out of step with developing international law. And that challenge is before the European Court of Human Rights. So immunities is one challenge and one area, I think, where the law really does need to be clarified. And again, we have very different approaches to immunity in courts around the world.
Thank you, Helen. And to you, Hala, before again moving to you, I'll just recall that, I mean, yes, the United States, the case was rejected, but we did have a very interesting report that was submitted to Congress, which was based on domestic laws and on basic and on national security policy instruments that required some vetting, some legal international law vetting before certain aid decisions would be implemented. And there have been other countries where legal proceedings of that nature have been initiated, for instance, in Germany, although there have been many obstacles on the path of these. I think that the Dutch one is the only one who cleared so far and resulted in a judgment, which is, I understand, on appeal. Moving to you, Hala, where do you see, despite the very dark past, do you see any hope for domestic courts in Israel or outside Israel producing some justice and accountability for war victims?
First of all, I would like to say to Professor Benishti, I would very much hope that there would be results coming out of the investigations he mentioned. I want to say, Yuval, that I am very skeptic about any justice coming from Israeli courts. I fully depend only now on international justice because the Israeli legal system has failed Palestinians during all these years. And I would like to say or to mention that we have seen, and also NGOs, human rights organizations have witnessed in the last war, in this war on Gaza, we've seen little or petitioning the Supreme Court by a human rights organization concerning Gaza. The petition on allowing the humanitarian assistance was as a result of the provisional measure that was given by the ICJ and a couple of human rights organizations. The Gisha petition tackled the issue of the humanitarian assistance. This is one case. We've seen a couple of cases by the Moked Center of the Defense of the Individual petitioned the Supreme Court on individual habeas corpus petitions to locate incarcerated Gazans held incommunicado and in unknown location by Israeli forces. We haven't seen any petitions by the largest human rights organization to the Supreme Court, and this means everything. In the previous war, there were more petitions about entering ambulances in Gaza, allowing medical aid or transferring wounded to Israeli hospitals or to hospitals in the West Bank and East Jerusalem. We don't see that in the current war, so the picture is really very gloom and dark. I want to say specifically about this war, when it comes to impunity, the issue of the detainees, the Palestinian detainees are held in horrific conditions, and abuse practices are taking place at detention facilities in Sde Omer, which Gazans from Gaza is being held in a very catastrophic conditions, handcuffed, transferred, they were enduring horror, big torture, and 27 detainees have been killed or died during their incarceration. Also, Israel has actually enacted, Knesset recently passed, not enacted, sorry, an amendment to the law on the imprisonment of illegal combatants, along with other new emergency regulations, granting broad powers to detain prisoners with little oversight or due process. So this is a really dark hole. All the issue of prisoners, detainees is a black hole. And just to give you numbers, administrative detainees, now we are talking approximately 3,424 detainees, unlawful combatant detainees 865, security detainees 2,727, security prisoners 2,072. I'm stating these information based on Hamoked, Center for the Defense of Individual data. And so the picture is really grim. And if you ask me, Yuval, I don't rely anymore. I mean, but when we talk about international law, we say international law, we have to exhaust local remedies before approaching international arenas. So we have to do that. We go to the Supreme Court, the Palestinians go to the Supreme Court, but nothing happens. So they exhaust the local remedies, no remedies, and the only way is international arena. Thank you.
Okay, so no optimism from you, Hala, today. No, I mean, it is a difficult period, of course. And you raise very serious issues. There are a number of questions. So maybe in the remaining time, in the 22 or 3 minutes we have, what I can do is I can basically ask whoever on the panel wants to deal with the questions that I will read to basically relate to them. We already have a few questions, and feel free to add more, and I'll try to insert them. So one set of questions is posed by Ben Clark, our friend who has been involved in these conferences also for many years. Not deterred by the time difference, apparently, because he is Australian. And Ben is asking essentially, is there a need for an interpretive guidance document on matters such as proportionality or what would constitute an acceptable, so to speak, operational mistake? And so the different courts around the world are able to apply these difficult issues of IHL in a more or less uniform manner, and whether we need some permanent mechanism to generate these sort of maybe practice guidance documents that would give us more concrete guidance. So I don't know whether anyone on the panel wants to address this issue of whether the standards, whether we have sufficiently uniform standards to effectively exacerbate the decentralization of the application of IHL, including the application by different courts to the same conflict, which is, I think, what we are increasingly seeing. Yeah.
Yeah, so I think it's a huge question, and there's a lot of potential in it. The question is, I mean, I think to answer this question, there has to be some kind of preparatory survey to see whether there's any consensus on the key issues, and whether there is a potential for a dialogue to elaborate and clarify things that are now disputed. We have to bear in mind that there are two cultures here. The culture of the IHL people that begin from humanitarian law, and there's the law found conflict people who see the war as the main preoccupation, and human rights come as a I wouldn't say not an afterthought, but as a conditioning factor on the purpose of the conflict, which is to win the war. These are two different philosophies, two different camps, and it's always, I mean, from my experience, it's difficult to come to a common ground. Remember the ICRC effort to elaborate on the concept of taking direct part in hostilities that ended with more dispute, more dissension rather than consensus. So I think it's fruitful to have such discussions. I'm not so sure that but there is we need actually to try to seek common grounds. If people can convince each other in a dialogue, that would be best. I'm not sure we can get it, but we should try.
Does anyone else want to add, or should we go to the next question? Alla, do you want to say? No.
Oh.
So maybe, I mean, feel free if you want, when you answer later, also to address previous issues. I mean, we're not going to be so organized. I'll just note before going to the next question, our friend Eitan Diamond, who is with Diaconia here, has noted that there is a petition actually by PICATI, the Public Committee Against Torture in Israel, which challenges the detention conditions, including in where Hala mentioned in the detention center in the south, the army base in the south that has been transformed into a detention center, and the hearing will be on May 27th. So late in coming, but it's moving a little bit forward. We have a few questions.
Sorry, Yuval, can I just add something? I want just to stress again, if we take the Chomat Magen, the Jenin operation 2002, then the Supreme Court, you could petition the Supreme Court, letting, as I've mentioned, ambulances in, transferring wounded, but nowadays you can't do anything. You can't intervene. You cannot say stop. You can't. No, there is no option to do that. So
no, I think you're right that we have gone from one extreme where you could petition during the siege of the Church of the Nativity, and you would have to negotiate the entry of water and food into the church, to, I don't know if the other extreme, but we have moved it to a much less interventionist court. But it may also have to do with NGOs and their interest in bringing these cases to begin with. So that's maybe a broader topic, because some of the NGOs have changed their position also with regard to the futility of bringing some of these cases. I see a question from Olivia Flash from the UK, and also Shani Friedman from Hebrew University, and also now in France, I think, regarding facts. And this is mostly relevant for third-party courts. And I think part of the concern that has been raised with decisions such as the Dutch decision on the limits, on the export limits, has been where do these courts get their facts from? And the answer, and we also see it in one of our chat box, is that they get their facts mostly from NGO reports, UN reports, and probably from media reports. And the question that raises whether this is good enough, given that at least I can say on the UN reports, we do have great which is a system which I know maybe better. There is a very great diversity, better than the other systems that I know. There is a great diversity in terms of methodology, comprehensiveness, seriousness. So no two reports are similar in terms of their probative value. So I mean, if maybe Helen, do you want to comment on this? Because I think this goes very much to the heart of how do you go about litigating these cases, and whether you how do you respond to concerns about the facts being a bit skewed?
It is a difficult one. I mean, undoubtedly, it's a difficult one. One of the major challenges that we haven't talked about is, of course, the evidentiary challenge, right? In terms of, I mean, in any type of proceeding, just during an armed conflict situation, how do you get access to enough of the facts on the ground? At the same time, I think there's a few different things, isn't there? I mean, one of them is what is it that the relevant court is trying to establish? So, there's, of course, as we all know, a mile of a difference between establishing individual criminal responsibility from civil responsibility of individuals, from whether there's sufficient risk, which was the Dutch question, whether or not there was sufficient risk for the Dutch to refuse under its own system to export in that situation. And I think when you're looking, particularly when you're looking at questions of risk, I think you have to take a broad approach to sources, and I think that's appropriate. Of course, if it was a criminal proceeding, we'd all want, as human rights-minded people, I would hope, to be very careful about the type of evidence that's being used, whether or not it can be refuted by the defendant, for example. This is a very different type of proceeding. So I think if you were relying on one NGO report, there would be serious questions. I don't think that's what happened in the Dutch case. I think the same arguments have been made about the ICJ, and I think, in fact, we had a massive amount of sources being drawn together in order to reach the decisions in relation to risk in that situation. So it is a challenge. but we have to work with what we have, and the onus at the end of the day can be on those that have access to more information to provide it if they feel that justice has not been done.
Yes, of course, it's not that the ICJ decision was not criticized on that basis as well, of course. And it is a difficult conundrum. Does anyone else want to add on evidence, or we move to the next question? Yes, Hala.
Just we have to remember that during the war, I mean, Israel does not allow any foreign press to enter the Gaza. So I mean, you get your information either from the combating parties, you get it from locals, you get it from people who can get to the international press. But how can you? No any fact-finding bodies are allowed to get into Gaza. So
yes, that's certainly a complication. Yes, it may be the situation that it's very hard to get clear facts when a military conflict is actually ongoing, and that's and there is a question of what happens then. So Eyal suggested that maybe the burden of proof and truth is on the state. But in legal proceedings, the tradition has not always been like that. I mean, you sometimes, if you make a claim, you have to establish that claim, even if the standard is not beyond reasonable doubt, but a clear risk standard or substantial grounds or reasonable grounds. I want to move maybe to the next question by Maria Varaki on the interplay between domestic litigation and domestic politics, and whether we are seeing these trends in the propensity of domestic courts to deal or not to deal with war situations. Is it somehow correlated to changes in domestic politics, which may make these cases more or less popular? Maybe Eyal, I can turn this to you.
Yeah. So obviously there is a linkage. I think that in situation of relative stability, like in long-term occupation, and this is what has happened in Israel in the last 50, 60 years. So there is more willingness of the public to have litigation being actually examined by a court. There is much less public support for judicial intervention where in situation of grave threat, and it's not. I'm not saying it to justify judicial silence. I'm saying that's part of the conditioning factor, social conditioning factor that might shape judges' willingness to intervene. So the judges are being judged, in a sense, to be impartial and independent, and open themselves up to criticism for their intervention in matters that the public does not support. And judges are always sensitive to the public perception of their acts and omissions. So here's one challenge. The other challenge is when the political branches do not appreciate the court's intervention. They don't benefit from the sense of objectivity that and the support that they get from the court. So here's another challenge. So these are the two main conditioning factors for court's intervention. Now, what has happened is that the external branch, if you want to call it this way, so third-party courts, third countries courts, international courts, they bring their own pressure onto courts, and they may convince the political branches, they may convince the public to allow domestic institutions to operate effectively. And that's the challenge that Israel faces now. And I think that ultimately this was the whole idea behind universal jurisdiction and behind International Criminal Court and the principle of complementarity. So here's the challenge now, and here's the pressure, political pressure or legal pressure, that may counterbalance the domestic political pressure against judicial intervention.
Yes. Of course, in Israel, we are now also experiencing exactly the opposite narrative is also being put forward, that for many years, the court has been regarded, at least by its supporters, as a shield for the state against international jurisdiction. And now, critics of the court are saying, where is your shield? What is happening with your shield? So it could cut both ways. I will go, in the interest of time, maybe I'll go to the next. I have two more questions, maybe more will add, and maybe I will pose both of them, and you will have a final round in which you can address the questions and maybe say some other concluding thoughts. And Hala, I'm warning you that we will start with you this time, okay? So we will go in reverse order. So another question from Olivia Flash has to do with, do you see also a room for newspaper responsibility as part of this proliferation of judicial proceedings? And she's mentioning that the number of victim families from the Israeli side who have been murdered on October, whose family relatives have been murdered on October 7 are suing news agencies for employing reporters who then were later discovered to be Hamas operatives. But also she's asking whether when media reports are then discovered to be false, whether this should entail legal responsibility, and whether these news agencies can be sued. Without going into any specific incidents, the claim is that false reporting could have actually real life impacts in certain cases, false news, fake news. And another question from Eitan Diamond, who I mentioned also before, is, and I'll read the question, is what evidentiary weight do panelists think should be attributed to statements by public officials to infer elements of legal analysis that require insight into knowledge, expectations, and intentions of parties? And he asked this in light of the extensive reference to such statements in international proceedings regarding Israel's actions. We heard a lot of discourse on what Amalek actually means under the different books in the Bible. But I guess that's the general thrust of the question: to what extent are these statements central to domestic litigation? So Hala, you don't need to respond to everything, just those parts that you still want to respond on.
Concerning the first question, if somebody can sue in defamation law, it depends where are you going to sue, in which country, what are the laws of the country, the specific country, and it depends if there's the evidence of it was a truth. This is private law. I think it's international private law. So I want to address the second issue. I think that two things about press, newspapers, and the media. I think that the media in the war on Gaza has played crucial. The Israeli media has played crucial role in I want to say preventing Israeli citizens of Israel from getting the whole truth about what's going on in this war. I mean, of course, people who are educated, learn, they can go read foreign press, but the Israeli citizens of Israel did not have a clue what is going on in Gaza, and I think this is a real problem, and I think it has to be investigated after the war, as Advocate Michael Sfard has written in Haaretz. This is a major issue affecting. I think you are depriving the Israeli citizen from even thinking, or depriving him from thinking of what to do about this war, if he should do anything, because they're not really getting the real or the whole picture. Concerning the evidentiary issue,
briefly, Hala, because
I think in the ICJ, when they were dealing with the incitement and inciting all the public figures in Israel calling for fight the Amalek, and I think these are the tools that we have, that courts have, in order to ascertain whether there is incitement. I mean, they would not go for a singer who sings. We're talking about people who affect soldiers, who affect the deeds, the orders in the battlefield. So it can be a minor, it can be a major, military figure, but it's very important. It has this effect on the Israelis. So I think it is very much important, yes, to pay attention to these issues. Thank you.
Thank you, Hala. Helen, to you, 1 minute, if you may.
Very briefly, I think newspaper responsibility, it's a very difficult question. My instinct is to say I think we do have to be very, very cautious. Clearly a level of accountability around fake news is important, but the form that accountability takes, I think we have to be careful. It should certainly be very exceptional. I think, the press is under siege. It's having implications for armed conflicts, and certainly for accountability and transparency, as we've discussed. So I think we do have to be ensure that is very exceptional. Evidentiary weight, I think it depends what weight things are given, but clearly I think the statements of officials have to be taken into account in terms of looking at knowledge and intent. I think inevitably that will be the case. It has to be looked at in the round, of course, and given the appropriate weight, and it depends on the nature of the proceedings again, but absolutely they have to be and will be taken into account, and maybe it will make people think before they speak, which might have other benefits as well.
Before they speak and before they tweet. To you, Eyal, the final words.
Just to say that it's very difficult to respond to all these questions in such short time, but I think to conclude, if I may, there are many important questions that are troubling us and troubling me personally these days, as an Israeli citizen, I think we are all entitled to answers from the army, from the government, and hope that the courts and investigating bodies would do their work. Thank you.
Okay, I don't think there's much disagreement in this panel. Maybe outside this panel, yes, but within this panel on this message. So thank you very much. I want to thank all of you and also Ben Sol for a wonderful and very inspiring and interesting panel. And without further ado, I would invite my friend and colleague, Professor Yael Ronen, to take over the moderating the MC position and to launch the next panel. Thank you very much.